So at this time, going to talk about the difference between a domestic violence crime and a restraining order, how they're processed through the system, and the differences between the two. So the first thing you need to know is that a domestic violence crime under the Prevention of Domestic Violence Act in New Jersey that was passed in 1991, also known as the Domestic Violence Act, a crime under that act is prosecuted by the prosecutor. It is a crime against the state. The prosecutor brings the case. That's why all crimes are state versus John Doe, John Smith, whomever the person is. So the prosecutor is bringing a crime, is bringing a charge of the crime. The legal standard that the prosecutor has to meet is called reasonable doubt, and that is the highest legal standard in law. Right? There are basically three main standards. Right? One is preponderance of the evidence. That is the lowest one. It's basically about 50% plus one. The second highest standard is clear and convincing evidence. It's high, right? And then the highest at the very top is reasonable doubt, right? Because reasonable doubt is an easier standard to meet. And if you're going to take away someone's, you know, freedom and lock them away for years and visit all kinds of consequences upon them, give them a criminal record, things like that, then it has to be a very high standard, right? Now, if you compare that to a restraining order, a restraining order is not a crime. It's not processed by the prosecutor. The only time the prosecutor may have anything to do with a restraining order is if there's a domestic violence crime. It's violent, right? And the facts suggest that there should be a restraining order attached automatically. The prosecutor may request for the judge, as a matter of formality, to say, "Hey, Your Honor, we're asking for a restraining order in this matter." In most cases, the judge himself or herself will impose a restraining order automatically if the domestic violence that is alleged, is a violent crime, right? So that's all the prosecutor has to do with regards to a restraining order. They don't do the case, they don't do the trial, nothing. The restraining order is a civil matter, right? It's a civil matter between one person and another citizen. And because it is a civil matter, although there is a trial, there is always a trial. But because it's a civil matter, the legal standard that you have to meet in order to win, in order to secure the restraining order by the judge, is preponderance of evidence, right? It's the lowest standard in law. Preponderance of evidence simply means, as we lawyers like to say, 50% plus one, right? So imagine 50%. You just need a little bit above it. It could be 50.1. It could be 55. It could be 73. As long as it is a little bit above 50%, that qualifies as preponderance of evidence, and that's the requirement. However, it is a full-blown trial, right? There are rules of evidence. There are procedural rules, although the rules are a little bit relaxed, I would say, but they still matter, right? And the reason why I said the rules are a little bit relaxed is because the rules of procedure, I would say, are relaxed, is because you don't get a full, you don't get as much time to do discovery. In fact, there's no discovery at all when you do a restraining order case. Unlike a civil litigation case where you have months of discovery, you're exchanging documents and evidence. With a restraining order, there is no such thing. Everybody brings their evidence to court the day of the trial, right? If you watch my other video when I talked about restraining orders, you how to get a TRO, a temporary restraining order, you understand that once a temporary restraining order is issued, it is served upon the defendant. Then they're told the date and time in the courtroom where the trial is going to take place and the address. And so, with that knowledge, both parties show up, bring all your evidence, right? The parties have notice. The defendant, for example, has notice of what the other party is alleging, because they get served with a copy of the complaint with this restraining order. right? And so you can see the allegations in there. If there's any documents, text messages, things like that, that would help defend defend the person against the claim, they can bring it to court. So the rules of procedure are relaxed in that sense. There is no discovery, right? However, when you are doing the actual trial, rules of evidence matter, right? You have to know how to do cross examination, direct examination, if you want to win your case. This is another reason why I don't advise people to try to secure a restraining order or defend the restraining order without the service of an attorney. I've been in court where the judge, where someone came in, said his whole case, they give the story, and the judge said it doesn't meet the standard because they didn't know how to present their case, right? I think that does it for now. In this video, we've talked about the differences between a domestic violence crime and the prosecution for that, and a restraining order on the other hand. Different legal standards, but again, this is Attorney Ade Omojola from Omojola Law, and I'm looking forward to solving your legal problem. Hello, this is Attorney Ade Omojola from Omojola Law, located right here in Jersey City, New Jersey. I have been practicing for over 14 years. I cover the areas of litigation, domestic violence, restraining orders, DUIs, driving under the influence, and also immigration. You can search a modular law into your favorite search engine. Just enter OMOJOLA space LAW, and it'll pull up our website, locations, and other information by which you can contact us. Again, this is Attorney Ade Omojola from Omojola Law, and I am looking forward to solving your legal problem.